This module is on rape as a human rights violation and covers the law in India from 2013. The content was written by Radhika Gupta. By the end of the module, you should be able to trace the evolution of anti-rape laws through amendments in substantive and procedural laws via the Criminal Law Amendment Act of 2013. Understand the significance of landmark judgments and public opinion in inducing legislative change in anti-rape laws. Critically understand and analyse certain contentious questions surrounding anti-rape laws in contemporary India. The 16th of December 2012 Delhi gang rape case involved the brutal assault and gang rape of a young 23-year-old woman by 6 men in a private bus in which she was travelling with a friend. The extreme injuries inflicted upon her resulted in her eventual death. The public outrage that followed the death of the young woman, who came to be known as Nirbhaya, demanded legal and social change and asked for the establishment of fast-track courts for speedy justice. One of the most problematic issues confronting the courts in the prosecution of the Nirbhaya accused was the criminal liability of a juvenile, that is, a person below the age of 18 years old, for heinous offences such as rape, even when the juvenile is close to the age of majority. One of the accused in the case was 17 years old and 6 months at the time of the gang rape. Juveniles, in conflict with the law, are tried under the Juvenile Justice Care and Protection of Children Act from 2000. They can be sentenced to a maximum punishment of 3 years in a reform facility, irrespective of the offence, and notwithstanding the degree of punishment for an adult committing the same offence. Usually, punishments vary from house arrests to counselling, curfew and probation. Despite great public demands to try the juvenile as an adult on account of the extremely violent nature of the offence and his proximity to turning 18 years old, including the Janata Party petition for the same, the juvenile was dealt with by the Juvenile Justice Board, as per the procedures of the above-mentioned Act. The defendant was held guilty of having committed rape and murder and given the maximum sentence of 3 years of imprisonment in a reform facility, inclusive of the 8 months he had already spent in remand during the proceedings. Ram Singh, the prime accused, was found dead in his cell in Tihar in March 2013, and the proceedings against him stood abated. The other 4 accused persons were convicted by the trial court and awarded the death penalty. The High Court of Delhi, on appeal, upheld the death penalty by placing the gruesome offence committed by the convicts in the rarest of rare category. Following the Delhi gang rape case, the Verma Committee, headed by the former Chief Justice of the Supreme Court, Justice J.S. Verma, was constituted on the 23rd of December 2012 to recommend amendments to the criminal laws in India, particularly with regards to crimes against women. Some of the important suggestions as to anti-rape laws were made by the committee are discussed below. The committee recommended that the definition of rape should be broader, beyond the confined scope of penile vaginal penetration, to include any non-consensual penetration, as advocated previously in Sakshi v. Union of India. This highlighted how sexual acts not falling within the strict and narrow construction of penile vaginal intercourse are classified as either unnatural offences under 377 or insulting public modesty laws. These therefore get more lenient punishments. The committee proposed a gender-neutral section for prosecuting men for raping both men and women, and not only women as per the current provision. Thus, as per the recommendations, while only a man may commit the offence of rape, it may be committed against any person irrespective of their gender. The committee also sought a wider compass that accommodated sexual assault against men, homosexuals, transgenders and transsexuals to facilitate law reflecting social reality. The committee recommended that the exception for marital rape in Section 375 should be removed. The amendment in 1983 allowed for prosecution of husbands for marital rape only if their wives were between the age of 12 and 15. This implies that wives aged either below 12 or above 15 years old would not be able to institute a criminal proceeding against their husbands under the ambit of Section 375 and 376. The Verma Committee recommended the removal of chemical castration and the death penalty as punishments for the offence of rape, due to the absence of a link between their deterrent value and the ability to prevent the problem of rape from its roots. The committee recommended enhancing punishment to up to 20 years imprisonment for rape and murder, and life for gang rape. The committee also recommended banning the two-finger test, conducted to ascertain the laxity of the vaginal muscles, thereby also removing the propensity to view any current case of rape in the context of the survivor's previous sexual history. The idea was not to let previous sexual activity or even current relationships colour the consent or quality of consent of the survivor. The committee recommended the establishment of a sexual assault crisis centre, operating in partnership with the Sexual Assault Helpline, conducting the medical examination under the supervision of a female gynecologist who guides the survivor through the procedure for uniform practice. The installation of CCTV cameras at police stations and questioning rooms, and technological means to file FIRs online. That the examination in chief and cross-examination should be conducted in camera in order to protect the testimony and identity of the woman, but the rest of the trial should ideally be conducted in an open court to enable women's organisations and the media to observe the court proceedings. They also recommended registering every complaint of rape reported by civil society organisations in police stations, and the failure to do so would make the specific police personnel liable for punishment. Imparting sex education in educational institutions and conducting adult literacy programs for gender empowerment, and a separate Bill of Rights for women to entitle them to a life with dignity and sexual autonomy, purportedly to recognise the significance of the woman's consent. The examination of chief and cross-examination to be conducted in camera in order to protect the testimony and identity of the woman, but the rest of the trial should ideally be conducted in an open court to enable women's organisations and the media to observe the court proceedings. They recommended registering every complaint of rape reported by civil society and police stations, and that the failure to do so would make the specific police personnel liable for punishment. Imparting sex education in educational institutions and conducting adult literacy programs for gender empowerment and a separate Bill of Rights for women to entitle them to a life with dignity and sexual autonomy, to recognise the significance of consent, were also recommended. The Criminal Law Amendment Act of 2013 followed the Verma Committee report. It was enacted to amend statutory provisions on sexual offences. The Act brought about the following significant changes in anti-rape laws in India. Changes to the Indian Penal Code of 1860, including the expansion of the definition of rape. Amendments to Section 375, which goes beyond penile vaginal penetration, to include within the meaning of rape other acts, such as penetration of the penis or other part of the body or any object, or putting anyone's mouth to the woman's vagina, anus or urethra. Inclusion of statutory rape. Under Section 375, it is now punishable for a man to have sexual intercourse with a girl not being his wife under the age of 18, irrespective of her consent. Earlier, this age was 16, and the meaning of consent was changed. Explanation 2 to 375 now explicitly defines consent as the unequivocal voluntary agreement through words or conduct indicating that women's willingness to take part in the particular sexual act has been given. Section 376 of the IPC has created additional offences, created greater punishments, and introduced the death penalty in specific circumstances. Section 3761 has increased the maximum punishment for rape from 10 years to life imprisonment. Subsection 2 has been extended to include members of the armed forces, guardians, relatives, teachers, men in a position of power and control compared to the woman, and punishes them for raping a woman incapable of giving consent or suffering from mental or physical disabilities, or for raping a woman during sectarian violence or repeatedly raping the same woman, or causing grievous hurt to the woman in the process of raping her, with imprisonment ranging from 10 years to the remainder of the person's natural life. Section 376A punishes a person who, in the process of raping a woman, either causes death or compels the woman to be in a persistent vegetative state with imprisonment from 20 years to life or even with death. The statutory provision of Section 376C for punishment for rape by a person in authority has been increased from 5 to 10 years of rigorous imprisonment, accompanied by a fine, and now also includes those in a position of authority or fiduciary relationship to another one, within the scope of the definition. Section 376E states that anyone already convicted under subsections A or D and as a repeat offender again would be convicted of the same would be punished with life imprisonment or the death penalty. Subsection B punishes a man who engages in sexual intercourse with his wife after a decree of separation has been passed. The punishment has also been increased from a maximum of 2 years to imprisonment of a maximum of 7 years with a fine. Gang rape has also been included under subsection D and has been included to provide for a punishment in cases of gang rape. Section D punishes a group of people acting in furtherance of common intention to engage in gang rape. The minimum imprisonment for gang rape is 20 years, which may extend to life, along with a fine sufficient to cover medical expenses and rehabilitation. Changes were also made to the Indian Evidence Act. Section 53A was added, stating, in the course of a prosecution for the offence of rape under sections 375 and 376 of the IPC, on the issue of consent, evidence of the character of the victim or of such a person's previous sexual experience with any person shall not be relevant on the issue of such consent or the quality of consent. It should be noted that earlier in the year 2003, Section 146 of the Indian Evidence Act had also been amended to provide that questions regarding a survivor's general immoral character or past sexual experience are not permissible to establish the existence or quality of consent. Changes were also made to the Code of Criminal Procedure. The amendment to Section 154 necessitates the recording of information from a woman alleging the commission of an offence of rape against her by a woman officer and requires such information to be recorded at the residence of the person seeking to report such an offence. An interpreter or a special educator, if needed, should also be present. The reporting of an offence under Section 164 states that when an offence of rape is alleged, the judicial magistrate is obligated to record the statement of the survivor as soon as the commission of the offence has been brought to the notice of the police. An explanation was inserted into Section 197 stating no sanction is required against a public servant accused of committing the offence of rape. Under Section 273, evidence of a woman below the age of 18 years allegedly subjected to rape or any sexual offence must be conducted in a manner to ensure that she is not confronted by the accused, whilst also ensuring that the right of cross-examination of the accused is not hampered. Section 309 has been amended to provide that an inquiry or trial in proceedings relating to rape shall, as far as possible, be completed within a period of 2 months from the date of the filing of the charge sheet. Section 357C has also been inserted to provide that all hospitals, public or private, and local bodies or any other persons must immediately provide first aid or medical treatment free of cost. This must be made available immediately, and they should also inform the police of such an incident. In recent years, the Apex Court, in its various judgments, states that a conviction is possible solely on the statement of a prosecutrix, provided that the statement is found to be reliable. It is a settled principle of law that conviction can be based on the sole testimony of the survivor of sexual assault, without corroboration from any other evidence. It is a settled principle of law that conviction can be based on the sole testimony of the survivor of sexual assault, without corroboration from any other evidence. When the testimony of the survivor of sexual assault instills the confidence of the court, it may be relied upon for conviction of the accused. It is also a well-settled principle of law that corroboration as a condition for judicial reliance on the testimony of the prosecutrix is not a requirement of law, but a guidance to prudence under the given circumstances. The Supreme Court in Vijay Achini v. State of Madhya Pradesh has dealt with the issue of a sole testimony and held, thus, the law that emerges on the issue is to the effect that the statement of the prosecutrix, if found to be worthy of credence and reliable, requires no corroboration. The court may convict the accused on the sole testimony of the prosecutrix. It is a settled legal proposition that once the statement of the prosecutrix inspires confidence and is accepted by the court, a conviction may be based on the solitary evidence of the prosecutrix, and no corroboration would be required, unless there are compelling reasons which necessitate the corroboration of her statement. Corroboration of the prosecutrix's testimony as a condition for judicial reliance is not a requirement of law, but a guidance of prudence under the given facts and circumstances. There is a katana of judgments passed by the Honourable Apex Court wherein it has been held that the deposition of the prosecutrix by itself is sufficient to record a conviction for the offence of rape, if that testimony inspires confidence and has a complete link of truth. In Muhammad Ali v. Uttar Pradesh, the Honourable Apex Court held, "Be it noted, there can be no iota of doubt that on the basis of the sole testimony of the prosecutrix, if it is unimpeachable and beyond reproach, a conviction can be based." And in Muhammad Iqbal v. the State of Jharkhand, it was held, "There is no prohibition in law to convict the accused of rape on the basis of sole testimony of the prosecutrix, and the law does not require that her statement be corroborated by the statement of other witnesses." On the other hand, there is the crucial reality where fake rape cases are filed by women and have been reprimanded by the Supreme Court. The Indian legislation completely negates the fact that men can be victims too. In 2015, cab driver Ramesh was accused of rape by one of his passengers. She accused him of forced oral sex and sexual intercourse. It was only 6 months later that Ramesh was declared innocent and that it was established that no rape was committed upon the woman, and the allegations had emerged because the woman refused to give the man his 500 rupee fare. In 2017, 4 women from Marawi were put on trial in Rohtak for filing false rape cases. A report by the Delhi Commission of Women in 2015-16 revealed shocking statistics showing that 53.2% of rape cases filed between April 2013 and July 2014 in Delhi were found false. The current situation in the country regarding harassment is nothing short of deplorable. Remaining contentious issues include marital rape and the two-finger test. One of the most problematic notions still embodied and preserved within the IPC is Exception 2 to Section 375 that disentitles wives above the age of 15 to acquire a cause of action against their husbands due to sexual acts or forceful intercourse. Exception 2 provides that sexual acts by a man with his own wife, the wife not being under the age of 15, cannot constitute rape. This implies that a husband raping his wife who is below the age of 15 does amount to rape. Problematic is the overt recognition of non-compliance of conditions for a valid marriage in India. For instance, Section 5, subsection 3 of the Hindu Marriage Act 1955 requires the bride to be of 18 years and the bridegroom to be 21. The acknowledgement of sexual acts within the compass of child marriages at one level can be construed as reflective of socio-legal reality. Yet, at another interpretation, provides for a dichotomy in legal standards on account of multiplicity of laws. Marital rape is not a criminal offence in India, with the only exception being a remedy under Section 376B when the husband commits an act constituting sexual assault when living separately from his wife. Cohabitation having been ceased after a decree of judicial separation has been passed does not fall within the ambit of marital relations at the time, and thereby disentitles cohabiting wives to claim for relief under the statutory provision. Various theories revolve around the contractual nature of a marriage, wherein a wife is said to implicitly consent at the time of marriage to sexual intercourse at the desire of the husband for the duration of the relationship. The contractual theory permeates into the matrimonial home by reinforcing this notion of women as chattel, which is meant to justify the burden borne by the wife by virtue of the sexual desires of her husband. Many skeptics fear misuse of a marital rape provision, claiming women might take undue advantage of the ordinary difficulties or wear and tear in marital relationships and make false allegations of rape against their husbands. The Justice Verma Committee specifically recommended the removal of the exception regarding marital rape by citing the judgment of the European Commission on Human Rights in CR versus UK, where a rapist was held to be a rapist irrespective of his relationship with the survivor. Further, the committee recommended a provision to specify that any relation, marital or otherwise, between the perpetrator and survivor could not form a valid defence for the criminal offence of rape. It also could not be used as a relevant factor to decide the existence or otherwise of consent, and could not be regarded as a mitigating factor justifying a lesser punishment. However, in India, the Criminal Law Amendment Act of 2013 failed to give effect to these recommendations and continues to immunise marital rape. Another contentious issue is the two-finger test. A doctor can perform the two-finger test by inserting a finger into the female's vagina to check the level of vaginal laxity. This is used to determine if she is habituated to sexual intercourse. This formed a crucial part of the controversy surrounding the Mathura judgment, wherein the trial court reaffirmed its dependence on the two-finger test to establish that the survivor's past sexual experiences, which implicitly had a bearing on her ability to consent and therefore to be raped. There have been judgments where the judiciary has condemned the practice and use of this test. In 1994, in the Narayanama versus Karnataka State. In 1994, in the Narayanama versus State of Karnataka case, the Supreme Court held that insertion of two fingers to check whether the hymen was torn or not was not reliable or sufficient evidence indicating that the woman was habituated to sexual intercourse. In the 2009 case, the state of Uttar Pradesh versus Munshi, the Supreme Court further reprimanded the medical examination processes for still using the two-finger test to pass judgments on the survivor's character. It assertively held that even if the woman had lost her virginity earlier, it could certainly not give a license to any person to rape her. It is the accused who was on trial and not the victim. So, as to whether the victim is of a promiscuous character is totally an irrelevant issue altogether in a case of rape. In 2010, Human Rights Watch called the test degrading and unscientific and urged the Indian government to ban the practice. The Indian Council of Medical Research's 2012 guidelines encouraged the continuance of the two-finger test and received profound criticism for the recommendation. In Narendra Kumar versus the State of Delhi, the court in 2012 further opposed the practice of the two-finger testing and the connotation it held regarding the supposed incapacity of a woman to be raped if she had once in her life consented to sexual intercourse or a regular sexual life had been had. The apex court held, even in cases where there is some material to show that the victim was habituated to sexual intercourse, no inference of the victim being a woman of easy virtue or a woman of loose moral character can be drawn. Such a woman has a right to protect her dignity and cannot be subjected to rape only for that reason. She has a right to refuse to submit herself to sexual intercourse to anyone and everyone because she is not a vulnerable object of prey for being sexually assaulted by anyone and everyone. The Supreme Court took all such views into consideration in 2013 when it condemned the two-finger test in the case of Lilu at Rajesh versus the state of Haryana. It adamantly held that the two-finger test and its interpretation violate the right of rape survivors to privacy, physical and mental integrity and dignity, thereby disentitling any entity from using it to give rise to a presumption of consent. The Verma Committee report assertively held that the size of the vaginal introituses is predominantly overemphasized and therefore a medical examination involving the two-finger test to ascertain the laxity of the vaginal muscles is irrelevant and redundant. Indrajit Kandekar's in-charge Clinical Forensic Medicine Unit study report titled Pitiable and Horrendous Quality of Forensic Medical Examination of Sexual Assault Cases triggered the rise of social activism demanding the institutionalization of standard protocol for appropriate medical treatment of survivors of sexual assault. The Department of Health Research and the India Council for Medical Research's new set of national guidelines, approved by the Union Health Ministry in 2014, officially bans the use of the two-finger test in medico-legal cases and encourages requisite training and sensitization of hospital staff to enable removal of the social stigma attached to the rape that victimizes the woman further. However, despite repeated recommendations that the two-finger test not be used in medical examinations, prescribed medical textbooks still retain the test as a method to ascertain the occurrence of rape. The fear of false allegations of rape by women has made Indian textbooks on medical jurisprudence blindly promote the test without highlighting its shortcomings and leading to prejudicial medical evidence. These very books are followed in the process of preparing medical reports to be submitted to courts as scientific evidence. And therefore, unless the medical guidelines are effectively adopted, medical syllabi changed and forensic evidence books revised, the two-finger test, though contrary to statutory provisions, will continue in practice and disentitle rape survivors to the justice they deserve. The controversy surrounding capital punishment verdicts for committing the criminal offence of rape was stirred by the verdict of the 2012 Delhi rape case, wherein all of the accused parties, except for the minor who was sentenced to imprisonment in a juvenile cell, were given a sentence of the death penalty. A huge number of people turned to the streets protesting against the incident and demanding the death penalty for the culprits. Advocates of capital punishment inevitably argue from the standpoint of deterrence. They argue, the message such a penalty sends out to society is that of state vigilance, whereby the state considers violence against women a grave human rights violation and is ready to take stringent measures to punish the offenders thereof. On the other hand, human rights activists condemn the use of the death penalty as punishment for any offence. Amnesty International, for example, has condemned the Indian judicial system and has argued that the death penalty does not serve as a deterrent. Further, it is argued that instead of enhancing the punishment to death, the focus should be on institutional, procedural, and legal reform in a manner that provides a stringent, effective, and efficient executive machinery that is able to create a link between the commission of an offence and getting caught by the police functionaries, or immediately responding to FIRs. Further, some feminists argue that the basis for imposing the death penalty for the offence of rape is rooted in the notion that rape is the most heinous crime that may be committed against a woman, and is equivalent to almost killing a woman. They argue this reinforces the notion that rape survivors have had a crime that leaves inescapable, lifelong injuries of shame that are reinforced by society, thereby limiting her life choices. They argue that the death penalty therefore reinforces, rather than tries to correct, the disproportionate focus of the blame of the crime and the shame experienced onto the woman and not the perpetrator. After the 2013 amendments, Indian law provides the death penalty as a possible punishment where rape results in persistent vegetative state or the death of the woman. This module has focused on the 2012 Delhi gang rape case, which led to the formation of the Verma Committee and the subsequent criminal law amendments that were made in 2013. The module has also identified some of the key legal provisions that exist today and some of the contentious issues that still affect women's dignity and equality before the law in prosecuting crimes of rape. The module has also touched upon some of the difficulties in implementing reform measures when there are multiple authorities and perspectives and continuing practices to address.